From the heartland of America, it's the Bail in the Midwest podcast, hosted by Shane Rolf. Executive producer, David Stuckman.
Hello and welcome to the Bail in the Midwest podcast. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 39 years. Now, we don't have a guest today, but I do want to talk about cashless bail and talk about some specific cases where cashless bail has led to horrible outcomes. Now, cashless bail has a bunch of different names. In Kansas, we call it a personal recognizance bond or a PR or OR bond. In California, they're called zero bail. In Texas, they're called personal bonds. Iowa calls them PTA or promise to appear bonds. Every state has sort of a different name for it. The president refers to this type of release as cashless bail, which is a good shorthand term. He's even issued an executive order where he intends to tie federal criminal justice grant funding to the use of cashless bail in violent crimes. If you're granting cashless bail in violent crimes, you might lose some of your federal funding. But whatever name is used, a PR bond is a decision of the judge to release a defendant back into the population on nothing but that accused criminal's promise that he will reappear to answer the charges against him. In theory, if this person fails to appear and cannot be found, he would then owe the state the full amount of whatever the bond was. In reality, the state obviously cannot collect from a missing party. If you're not there, the state can't get any money from you. And in practice, the state almost never actually attempts to collect this debt at all. So in short, cashless bail is a meaningless, unenforceable promise from a highly unreliable party, i.e. a criminal defendant. So some cases here. Iryna Zarutska was murdered on the subway in Charlotte, North Carolina on August 22nd, 2025. Now, we talked to Michael Woody from the North Carolina Bail Agents Association in episode 43 and went into that case a little bit more in depth. But the murderer, DeCarlos Brown, had been arrested 14 times before, including for armed robbery and felon in possession of a firearm. He had served 5 years in prison. Several months before the murder, he was arrested for misuse of the 911 system. Just a misdemeanor. But the arresting officer said in court filings that Brown believed he'd been giving a, quote, man-made material that controlled when he ate, when he walked, when he talked. Pretty clearly, by putting those things into the court filing documents, they were trying to let the magistrate judge know that Brown was crazy, or at least had some mental health issues that really needed to be addressed. However, rather than ordering a competency evaluation or a mental health screening or any of the various tools that the courts have at their disposal, the magistrate simply released him on an unsecured bond, cashless bail. The last action in the case was his defense attorney filing a request for a competency evaluation. So his defense attorney was trying to say, hey, this guy's not all there. So DeCarlos Brown was a convicted felon, an obviously crazy person, out on a signature bond when he brutally murdered Iryna Zarutska. Now, we've all seen the picture in the video. It was horrible. But within a month of the murder, the North Carolina legislature had taken emergency action and passed Iryna's law to limit the use of cashless bail in North Carolina. So if we go to Chicago, just this past November, Bethany McGee was set on fire on the subway by a man with over 70 prior arrests, who was also out on cashless bail for an aggravated battery, which is a violent felony, due to the state of Illinois' Safety Act, which mandates zero bail release in virtually all cases. Now, we talked about the Safety Act in episode 17, so if you want to go back and take a look at that. But unlike North Carolina, the state of Illinois has done nothing in response to this horrible attack. Someone who's lit on fire on a subway stand. But here in Kansas, we don't have to look to Chicago or North Carolina for examples of this. We can just look to Douglas County. Lawrence, Kansas, the home of the University of Kansas, the Jayhawks, Allen Fieldhouse, all that basketball stuff. As with most college towns, there's a very progressive approach to things. And unfortunately, that approach extends to cashless bail. We need only look at the case of William Klingler, who is currently sitting in the Douglas County Jail on a $500,000 bond for leaving the scene of a fatality accident, driving while suspended, and failure to have an interlock ignition device. This case was filed in response to the death of Elsa McGrain, a 20-year-old pre-med student at KU who was just out for a jog. The police found fibers from McGrain's clothes in the grill of Klingler's truck and found one of the ear cushions of her headphones on the driver's seat of his vehicle, and the other ear pad was still with her body on the side of the road where he'd left it. I honestly don't know why he hasn't been charged with some sort of murder charge yet. He's simply charged with leaving the scene of a fatality accident. But as awful as this is, it's so much worse because it didn't have to happen. Mr. Klingler has an extensive criminal history dating back almost 20 years. He has served time in the Kansas Department of Corrections for tampering with electronic monitoring equipment and was just released in March of 2022. And for those who don't know what tampering with electronic monitoring equipment is if you have an ankle bracelet on or some sort of house arrest equipment that's supposed to be monitoring you either post-conviction or pre-trial, and you try and disable that in some fashion, you can be charged with an additional crime of tampering with electronic monitoring equipment. But at the time that he killed Miss McGrain, Mr. Klingler was out on bond, a cashless bail, a personal recognizance bond, for a fourth or subsequent DUI, which is a serious felony in Kansas, possession of methamphetamine, which is also a felony in Kansas, and circumventing an interlock ignition device. From the court record, it appears that this was his fifth DUI in Douglas County alone, and there's some reports that he may have had another DUI in Ohio, so this is probably his sixth DUI. The previous year, in 2023, just a year after his release from prison, he was convicted again of circumventing an interlock ignition device. In both of his 2019 and 2018 DUI cases, he was also charged with circumventing an interlock ignition device. Further, in the various cases he had leading up to 2024 DUI, there were at least 6 different instances of him failing to appear in court. So, in short, if you're looking at this guy as a criminal defendant, you go, oh, he doesn't go to court, he continues to drink and drive, and he either tampers with or circumvents the electronic monitoring equipment designed to prevent him from driving. Now, he was even working as a DoorDash driver at the time this accident occurred, or crime. So when he gets the fifth DUI, or sixth, in 2024, you expect that the court's going to throw the book at him, maybe set a really high bond, maybe order house arrest with alcohol monitoring, right? But instead, he's not even arrested. He sent a summons, which is basically just a letter telling them, hey, charges have been filed against you, you need to appear in court. And of course, he doesn't appear in court, and no great shock there. So when he fails to appear at the initial hearing set on the summons, the court actually does issue a warrant for his arrest. And on the warrant, they set his bond at personal recognizance, more cashless bail, despite the extensive criminal history and the history of failure to appear and the failure to appear for the summons. Now, admittedly, the bond did have a condition of no consumption of drugs or alcohol or mind-altering substances, but nothing was there to ensure those conditions were even followed. So 2 months later, he's arrested on the warrant, and he's immediately released on the signature bond. And note, he used the same address where they mailed the summons. So he obviously received the first summons and simply chose to ignore it. So he makes a couple of court appearances in December. He doesn't appear in February, but the court continues the case for a week, and he appears, and the case is set for what we call an evidentiary hearing or a go preliminary hearing. That means they're going to have witnesses come on, and they're going to at least try and establish beyond simple probable cause. They're going to try and get him bound over for trial. And of course, he doesn't appear. The court issues a warrant. This time, they set an $8,000 surety bond. So they finally said, enough of these. This is 3 failures to appear already. We're going to make you postpone. Takes him another 2 months for him to get caught. So he posts the surety bond. So he does get out with the bondsman. The case is continued to August 8th, and he doesn't appear. But But in this instance, since it's a surety bond, since there's a bondsman involved, he's back in custody in just 3 days. The bonding company's on the hook for thousands of dollars, so they get him back in. I figure, okay, finally, keeps missing court, not doing what he's supposed to do. We're going to keep him here. But just a week after that, on August 18th, so 10 days later, his attorney files a motion to modify the bond. In that motion, there are 2 arguments. The first is that he's only charged with, he's just charged with only 2 felonies, because only 2 felonies is minor. And that'll just likely result in probation, so there's no reason for him to sit in custody. And additionally, the motion claims that Mr. Klingler has always been respectful to the court, but apparently, evidently not showing up for court is not considered disrespectful. So despite there being 4 missed court dates in just this case, and at least 6 other missed court dates in his criminal history, and repeated violations of his electronic monitoring conditions, and it being at least his 5th DUI, the court modified his bond back to a personal recognizance bond and let him sign himself out. And he was out on this PR bond when he killed Miss McGrain. There is absolutely no reason, given his criminal history, for him to be released on any sort of cashless bail. But let's look at another case. As tragic as Elsa's death is, it's certainly not the only one committed in Douglas County by an obviously dangerous individual who'd been released on cashless bail. Let's take the murder of Gina Reyes Wohler, a mother of 2 and a member of the Cheyenne River Sioux tribe. Now, Lawrence has a large Native American population because, along with the University of Kansas, Lawrence is also home to the Haskell Indian Nations University, so there's a large population of Native Americans in Lawrence as well. Gina was stabbed to death on August 29th, 2025, just a few weeks before Elsa McGrain was killed. Now, a man named Aaron Blake Wright was arrested almost immediately for the murder. Now, Blake had been previously convicted of attempted first-degree murder and attempted second-degree murder for sending an explosive device to, quote, someone with the same last name as him, according to the Lawrence Journal-World, the local paper. And he spent 15 years in prison for these attempted murders. Now, in 2019, after he was released from prison for the attempted murders, he was arrested for felon in possession of firearm and another DUI, or a DUI. So a previously convicted attempted murder with a gun is not a safe situation. Now, this case sort of fell apart after about 13 months in jail with a lot of pro se, which means motions he filed himself, and even filed a lawsuit against his court-appointed attorney claiming he was doing a bad job. The case was ultimately dismissed. Now, looking at this from my experience, I suspect this dismissal occurred because Mr. Wright had already served 13 months in custody, and that was probably the bulk of the sentence he was facing. And the prosecutor didn't really want to devote any more resources to it if he was just going to get released time served when the conviction finally came down, because, you know, it's not a tough one. Either you had probable cause for the stop and there was a gun in the car, or there wasn't. So fast forward. By August of 2024, he had returned to Lawrence, Kansas, and was arrested for felony auto burglary and attempted theft. He was caught in the act and booked into the Douglas County Jail. He was taken to court the very next day. And despite the fact that he's a convicted attempted murderer ×2, he was released on a signature bond. The bond had conditions that he obey all laws and not consume any drugs or alcohol. By March of 2025, so about 6 months later, he was staying in a homeless shelter. The auto burglary case was still ongoing, and he was arrested again, this time for criminal threat against a law enforcement officer, which is considered a violent felony. Battery against a law enforcement officer, which is a violent misdemeanor, and disorderly conduct by engaging in brawling or fighting. All 3 of those offenses are considered violent crimes in Kansas. Once again, he was taken before the judge the very next day. And despite the fact that he had 2 attempted murder convictions and his criminal history, and he was already on bond for another felony charge that was conditioned on him not committing any new crimes and not having any alcohol, he was once again granted another signature bond. 5 months later, while still out on 2 different signature bonds for 2 different felonies, he's accused of murdering Gina Reyes Wohler. He was arrested within hours of the murder because they were drinking out behind a building. Wasn't supposed to be drinking. He had blood stains on his clothes and a bloody knife in his pocket. And so finally, we'll do one more. Still in Lawrence, Kansas, on September 10th, 2025, a Lawrence police officer, Marcellus Mitchell, followed a man named Larry Gatlin, followed his car for a few blocks. He didn't pull Mr. Gatlin over, but once Mitchell separated from Gatlin, he passed his car and went in front of him. Gatlin then fell in behind the patrol car and at the next stop sign began revving his engine right behind the car. So he pulls up behind the officer, starts revving his engine really aggressively. And so the officer gets out of his patrol car to go, what's going on? And Gatlin told the officer, and I'm quoting directly from the affidavits here, don't ever get behind my vehicle again. If you get out of your car, I'll get my 7.62 from the trunk. Now, Officer Mitchell obviously took this to be a threat, since 7.62 refers to ammunition for high caliber rifles like an AK-47. Now, upon hearing the threat, Officer Mitchell fled the area, believing that there was not a manner in which he could safely respond to the defendant. Now, I don't really understand why he fled the area instead of calling for more officers, but be that as it may, a warrant was issued for Gatlin the very next day, and he was arrested the very next day on a felony charge of criminal threat against a law enforcement officer. Now, his bond was initially set as a secured bond of $10,000, meaning he could post either $10,000 in cash or he could use a bail bondsman authorized by the court. He didn't post that bond. Instead, 4 days later, the court changed his bond to a signature bond, allowing Mr. Gatlin to sign himself out of jail, despite the allegation that he had threatened to shoot a police officer if he dared to follow his car. Less than 2 weeks later, he was arrested again, this time for stalking and driving while suspended. So his license was clearly suspended when the officer stopped him the first time, or when in his first engagement. In this case, Gatlin is alleged to have gone to the house of Elizabeth Hafoka in the middle of the day on September 28, 2025. At that time, Gatlin began repeatedly ringing the doorbell and banging on her door. When no one answered the door, he left the house and peered into one of Hafoka's vehicle's windows. Police arrived on the scene and spoke to witnesses, several of whom said that the defendant, Gatlin, was yelling that a witch lived there while pointing to Hafoka's house. Now, I keep saying the name Hafoka because it's important to note that Elizabeth Hafoka is the prosecutor for the city of Lawrence. She had prosecuted the defendant in the past, and this was clearly some sort of intended retaliation for those past prosecutions. Now, as might be expected, when someone within the criminal justice system is the victim of a crime, a warrant was quickly issued with a secured bond, and his previous signature bond was revoked. Thank God. These crazy judges have finally come to their senses. Right? 17 days later, despite the victims in Mr. Gatlin's cases being a police officer and a municipal court prosecutor, the court changed both of his bonds back to signature bonds and released him. But at least the judge ordered a GPS price that established an exclusion zone around the prosecutor's house and indicated that he wasn't supposed to drive. So I guess that's something. But on February 10th, 2026, Mr. Gatlin, who, as noted, is not supposed to be driving, his license is suspended, and his defense attorney assured the court that he would not drive and that his family had no problem paying for an Uber if he needed to get someplace. Mr. Gatlin was involved in a high-speed chase with officers in the next county over, Wyandotte County. Ultimately, he crashed his car, apparently into a police car, and is now in custody in that county for aggravated battery on a law enforcement officer, aggravated battery with a motor vehicle, fleeing and eluding, and the host of traffic offenses that go along with any sort of police chase. Thankfully, no one was killed this time, but, he is charged with aggravated battery on a law enforcement officer, so it may have been a close thing. Now, no doubt, I could continue to scour the court records of the Douglas County District Court and find multiple other examples of violent crimes committed by people who were out of jail on cashless bail. But as Joseph Stalin once said, one death is a tragedy, a million deaths is a statistic, and statistics dull the message. But what difference does it make? What difference does it make how they got out? I mean, they're just going to do the same thing. There are those who will try to claim that it doesn't matter how a defendant gets out. If they get out on a secured bond with the bondsman, the same thing will happen. It's just fate. Nothing we can do. Now, for that argument, I would point to a study done by the Yolo County, California District Attorney's Office. For almost a year during COVID, California engaged in wholesale release on zero bail. What that did, in addition to increasing crime, was to provide comparison data. The DA was able to compare similar charges with similar defendants within the same geographic area, with the only difference being the method of release. Jeff Reisig, the Yolo County DA, was actually a guest on this podcast in episode 24. So if you want more details about that study, you can certainly go there. But since that episode, he has refined his study even further, trying to be as accurate as possible, trying to get the best matching he can. Some of the highlights of the new study were that there were more new felonies. People released on zero bail, and keep in mind, California calls cashless bail zero bail, committed new felonies 103% more often, so double than people who posted a secured bail. More new misdemeanors. People released on cashless bail committed new misdemeanors 130% more often than those who posted bail. And there were more multiple arrests. People released on zero bail were arrested more than once over an 18-month period, because that was the time he was looking at. It was an 18-month stretch, 169% more often than those released on bail. And more importantly, and to the point that we're addressing here, there are more new violent offenses. People released on zero bail committed new violent offenses 175% more often than those who posted bail. Now, the statistic doesn't sound quite as damning, but this is almost 3 times more likely. If you post a bond without a bondsman, you are 3 times more likely to commit a new violent offense than if you posted bond with the bonding company. Now, other jurisdictions have gone to cashless bail releases has also suffered. Harris County, Texas is experiencing FTA rates or failure to appear rates as high as 80% on their personal bond releases. Cook County, Illinois, which is Chicago, where Bethany McGee was lit on fire, is actually manipulating its data by rescheduling court dates upon a failure to appear rather than issuing a warrant. They send out a postcard, and that postcard doesn't count as a failure to appear event for data collection purposes. In the first 9 months of the SAFE-T Act, they sent out 75,000 postcards. In that 9-month period, out of 91,000 cases, defendants missed court 67,000 times. And that's according to Irish Martinez, who is the former chief clerk for Cook County. Now, North Carolina, with Iryna's law and other states, are trying to roll back these cashless bail releases. The president is trying to add a financial incentive to limit these zero bail releases in violent crimes. Kansas is even looking at legislation this session to try and return sanity to pretrial bond setting. Unfortunately, this only seems to come after particularly gruesome and preventable tragedies. We've seen it happen in jurisdiction after jurisdiction. Kansas is not immune from this. Nowhere is immune. If you release accused criminals without accountability, you're going to get more crime and likely more violent crime. We have to hold their official feet to the fire to put a stop to this craziness and prevent more families from suffering. Thanks for listening to me today, guys. But please join me on the next episode of the Bail in the Midwest podcast, where we'll continue to bring you critical information and conversations with people involved in the criminal justice system, and hopefully we can hold officials accountable for their actions.
Join us again next time for the Bail in the Midwest podcast, hosted by Shane Rolf and executive produced by David Stuckman.